Well, thank you very much indeed for the generous invitation. It's lovely to see you all again. Who'd have thought that we'd still be talking about lots of aspects of Brexit? And that's what I'm going to talk about. I prepared a talk which on the subject I discussed with Evelyn on visas and supply chains and pigs, all of which I've looked at, and I thought I'd talk a little bit about that. But I'm also conscious that some of you might be interested in what's going on in Northern Ireland at the moment. And so what I could do, if that would be of interest to you, is talk a little bit about that. But I thought I'd start with sharing my screen and talk a little bit about what some of you had kindly signed up to hear about, which is about visas and supply chains and pigs, which seems a rather random group of topics. But of course, these are the areas that have already particularly felt the impact of Brexit. Now, just before we get into the substance, I thought I'd just remind you of where we've got to and where we are. And just remind you about the legal framework under which we are operating. Now, for those of you who are lawyers in the audience, you will think this is marvelous. For those of you who aren't, you'll think this is really rather repellent. And I will try and keep the law references to a minimum. But it is worth bearing in mind that law has been actually at front and centre of Brexit. To remind you, although it now seems an eternity ago, that we left the EU with the withdrawal agreement. That's the Article 50 text. And the withdrawal agreement includes the Northern Ireland Protocol, which of course is what a lot of the fights are about at the moment. And although we left formally on the 31st of January 2020, in fact, we remained subject to EU law. I'll come back to that in a second. We remained subject to EU law until the end of the transition period. There was no extension of that period, despite repeated requests for it to be extended. We left everything to do with the EU on the 31st of December, and we started trading with the EU under the Trade and Cooperation Agreement, which came into force on the 1st of January, initially provisionally, but then on a more permanent basis. But also down the other side, you'll see too the main acts of Parliament which have been engaged. Actually, most importantly, is EUA, the European Union Withdrawal Act of 2018. And this is where all of the retained EU law was incorporated into UK law. And that's one of the big issues that came up with Lord Frost and in the Brexit Opportunities document on Monday, that we're going to get rid of lots of that retained EU law. That's a whole corpus of EU law that was dumped into the UK legal system. This act, the EUWA, the Withdrawal Agreement Act, largely amended the 2018 Act, but gave effect to the withdrawal agreement, including the Northern Ireland Protocol, including all the obligations under the Northern Ireland Protocol. And then there was also the Internal Market Act 2020, which essentially gave the UK its own internal market, albeit a very lopsided one, which very much favours England. And then finally, the EU Future Relations Act, which is a dog's breakfast of a piece of legislation, but that brought the Trade and Cooperation Agreement into UK law. And as you know, we left formally on the 1st of January 2020, or sub 21, and there was the Daily Express trumpeting the great success that Brexit was going to be and how marvellous it all was. And we knew there were going to be problems. We knew there were going to be problems right from the beginning. The musicians were quite good at jumping up and down at the beginning and saying, this is a disastrous deal for those who want to provide their services on a temporary basis, which it is. There were shortages on the shelves from pretty early on. And indeed, I think you will have all noticed that there continues to be shortages in the supermarkets largely to do with supply chain issues. And one of the much vaunted opportunities of Brexit was to do a trade deal with the United States. And of course, that has also gone belly up. And there are quite serious problems still with fishing communities, where the fishing communities actually engage in exporting of their fish, because the non-tariff barriers, the controls on fish, both leaving the UK and entering the EU, have caused a real problem for British fishing industry if they do export their fish. And of course, all the delays mean that the fish is less fresh, and of course is also carrying extra cost. So it was pretty clear early on that there were going to be problems. And I want to start a little bit with those supply chain issues, because they're the ones that are most pertinent at the moment. Now, the UK took the decision that when we left a year ago, that we would not apply any restrictions on goods coming into the UK. There wouldn't be formal checks, with some minor exceptions, because they were really worried that there would be empty shelves. But on the other hand, the EU applied its full panoply of checks this time last year, and so British exporters had to adapt very quickly, not least because, of course, the deal was only struck on Christmas Eve, and the new rules came into force on the 1st of January. So it really was a challenge for British exporters. But importers, those bringing goods in from the EU, have had a free hit for a year. But that free hit came to an end, at least partially, on the 1st of January. And there have been a bunch of new rules that came into force about which declarations have to be made on goods coming into the country. There's been a certain amount of checks to do with sanitary and phytosanitary, that's biosecurity, food safety controls. The government also introduced a new IT system on the 1st of January called the Goods Vehicle Movement Service, and everything has to be pre-lodged into that government vehicle movement service. Quite a good system, I'm told, but it's still got glitches because it's new, and there have been periods of outage of that system. And of course, it's been new for everyone, and so hauliers are having to get their heads around it. So there were new rules on goods coming into the UK, but not the full panoply of new rules. In addition, there'll be a whole bunch of extra rules coming into place, excuse me, from July on goods, particularly on SPS products. There have also been some restrictions on new rules on exports to the EU about paperwork. Now, all of this has created problems, exacerbated by the fact that the French apparently have demanded wet signatures on documents. In other words, you can't sign online, which has slowed things up no end. And you will have seen, if you read the Kent Online Messenger or the Guardian, that there are major problems at the border. If you look in any other newspaper, you would not know that there are often 20-mile tailbacks from Dover along the A20 and the M20. Now, this is partly to do with the new systems. It's partly to do with problems over paperwork. It's partly, the UK says, because the French are being unreasonable over these wet signatures. But it is striking that there is this protocol that has been put in place, that if things are getting too busy around the port of Dover, that there is essentially a stacking system along the A20. And that stacking system, which is called the Operation Travel Access Protocol, has been activated 20 times already this year, as compared to 69 times throughout the whole of last year. So it just gives you a flavour of how bumpy things have been. And these delays can be running to tens of hours. And it's a real problem for the drivers, because a lot of these drivers are paid per kilometre driven. And if they're spending 8 hours sitting in a truck trying to crawl along the A20 into Dover, they are not getting paid for this. So you know what will happen. They will eventually have to renegotiate their contracts, and their contracts will say they get paid for waiting time too. And of course, the costs will have to be passed on. Now, as I said to you, there's going to be further changes from July, particularly over SPS products. And the bottom line is that leaving the single market and leaving the customs union has generated significant administrative burdens for importers and exporters. Now, you might recall that the Prime Minister said on Christmas Eve that the TCA, the Trade and Cooperation Agreement, has not introduced any non-tariff barriers. This is fundamentally absolutely untrue. All of this paperwork is a non-tariff barrier. Now, although this cartoon is intended to amuse, and of course, it looks like people are carrying shed loads of paperwork just to get in and out of the UK. In fact, nearly all of it is done online, as I've said to you, through this GVMS system. But nevertheless, the quantity of paperwork is just enormous. Just to give you a flavour, my own brother actually imports goods into Northern Ireland, and he says that his small company has had to employ one extra person to do it, and the hauliers that they use have had to employ an extra 9 people just to deal with the paperwork. So if the only boom industry at the moment, and that was confirmed by a survey last week on LinkedIn, is being a customs agent or a haulier, because this is where the jobs are. But joking apart, it is a really serious matter, and that's why you've got these big queues at Dover. The other thing I wanted to say to you, this story might have caused you to smile, because one of the Tory MPs went down to Dover to have a look at it. He got out in a lay-by and put his foot in something really quite unpleasant. And he discovered it was human and not animal. And the other thing to note is that the UK still has not organised really very basic things like basic sanitary facilities for the drivers who have been kept waiting in this stack. So that's what I want to say about supply chain issues. I now want to say something about migration issues, so visas essentially. Just to remind you, first of all, what you see on the right is the old EU rules on free movement of persons. And essentially on the right, you had the right to move if you were a worker under Article 45, if you were self-employed under Article 49, if you were temporarily providing services under Article 56, or if you were a student or a person of independent means, PIMS, a person of independent means, and you had sickness insurance and also sufficient resources. And this had been baked into the treaty pretty much since the beginning. And of course, as we know from the diagram on the left is a reflection of why people voted Brexit. And it was done in a survey the day after the referendum. And the larger the font, the more people said that this was the main reason why they voted to leave. Now, as you can see very clearly, front and centre was the word immigration. So this gave Margaret Thatcher, sorry, it's an unfortunate slip of the tongue, gave Theresa May the go-ahead to make really significant and dramatic change, turning off free movement of persons, so everything on the right has been turned off, and introducing a new visa system. Now, the way the government sells the new visa system is that it treats both EU nationals and nationals from the Indian subcontinent in exactly the same way. Depending on your point of view, that's either a very good thing or a very bad thing, because it's made life a whole lot more difficult for everyone. It's not given Indians or Pakistanis the same level of access that Europeans had when free movement was in place. But Theresa May saw essentially the results of surveys like the ones I put on the left for you as justification for absolutely ripping up free movement, and that's indeed what has been done. However, there was a small matter of what was thought to be 3 million or so EU nationals already living in the UK. And as part of the withdrawal agreement, if you remember, the withdrawal agreement was the first text I mentioned to you, the withdrawal agreement text, which became part of UK law. Part of that was about the Northern Ireland Protocol, absolutely, but part of it was also about giving rights to EU citizens living in the UK and UK citizens living in the EU. And to be fair to our government, they did a very good job in creating an app which people could apply for what was called EU settled status. And if they applied for EU settled status, and if they worked for a university or the health service, in fact, it was very easy to get settled status. So for a large majority of the population, the EU settlement scheme has been a good one. But if you do not have a smartphone, if you've led a very peripatetic life, if you're living in an HMO and you don't have somewhere safe to keep all your paperwork, it's proved very difficult indeed to establish the length of time you've been in the UK, and the EU settled status scheme has not worked for you. But what we do know is that about 6.2 million people have now applied for settled status. We absolutely do not think there are 6.2 million EU nationals living in the UK, for the simple reason that there are a number of repeat applications. There are people who've made speculative applications and have gone back to their own country. But it is thought that there are about 5 million or so EU nationals living in the UK. It's a really quite significant number of non-nationals who've come to the UK in a relatively short period of time. So hang on to that concept that you've got a bunch of people with EU settled status. And now let's think about mobility after Brexit. So you have to work out, first of all, when did the individual arrive? If they arrived before the 31st of December 2020, and they're EU citizens, they will be covered by Part 2 of the withdrawal agreement. They will be able to get settled status. And if you have settled status, your rights are rather similar to those of free movement. You've got the rights to live here, to claim benefits, to have access to the health service. If, however, you arrived after the 31st of December 2020, you then have to work out what the position is. Now, if you're an Irish citizen, you're covered by the Common Travel Area. And that essentially gives you free movement between UK and Northern Ireland. But the legal basis of that, for those of you who are lawyers, you will see it's not very concrete. It's largely a memorandum of understanding. But if you're not Irish, then you look to see if the provisions on the TCA on services apply to you if you're European. And as I will show you in a moment, the TCA provisions on services are very narrow indeed. If not, then domestic immigration law applies to you, which is a visa system. So in fact, mobility after Brexit has become much more complicated, because you have to look to see whether the European who's presenting him or herself to the immigration officer, you've got to look to see when did they actually arrive, have they applied for settled status. You don't, the UK system is not one which is gives you settled status, you have to apply for it. Are you an Irish national? If you're not an Irish national, are you covered by the Trade and Cooperation Agreement, which, as I'm going to show you in a moment, is very limited indeed. And if the answer to that is no, then it's UK immigration law that applies, which is visas and all the costs associated. Now, let me just introduce you to some concepts under the Trade and Cooperation Agreement on services. And the next slide may blow your mind. The next slide explains how migration works under the Trade and Cooperation Agreement. And it's very much based on the WTO text, which is called GATS, the General Agreement on Trade and Services. And GATS allows for 4 different types of mobility. They're called modes 1, 2, 3, and 4, which you can see on the left. And there are different modes and different rules apply to each different mode. Now, I can go into it in a great detail, but what I wanted to flag up to you. So the easiest is the situation where I'm providing a service, giving a lecture or something to clients in France. I do it over the internet, and that's mode 1. Mode 2 is where my clients in France come to me to get a service in the UK, or vice versa. Mode 3 is the situation where I'm trying to set up, my company is trying to set up a business in France. But the one that's most controversial, but it's the one that people are most interested in, is mode 4, which is about moving individuals. And moving individuals, can I go and work in France? Well, the answer is it's very complicated indeed. Just to give you a flavor, I can talk in more detail later on, but many of you might not be interested in all of the gory detail. But I can only go and work in France if I can fall into one of these categories. I'm a short-term business visitor. I am a business visitor trying to establish a commercial business. I am a contractual service provider. I'm an independent professional, or I'm an intra-corporate transferee. All of these have technical meanings. And then you have to go and squirrel away at the back of the treaty at about page 2000 to see if your activity, even if you're an independent professional, is covered in the list. Now you might say, well, what about musicians? They're independent professionals, but they're not on the list, so they can't take advantage of those rights. Someone like me who might go to France to do research, I would be covered. I could go as a short-term business visitor, but the crucial thing is I don't get paid. And so those people who want to try and provide consultancy services in other countries are going to face considerable difficulty. And just to make matters even more complicated, and the font here is very small because I've tried to get it all onto one slide, but essentially, depending on what category you're moving under, whether you're a contractual supplier or a short-term business visitor, there's a list of what you can do. There are different periods of time for how long you can stay and what rights you can get. But the crucial thing to understand is that even with all of these rights, and these rights I emphasize are very narrow, even with these rights, what you discover is that individual states like Spain can say, actually, we're not going to let you do it anyway. And so you again have to squirrel at page 2200 of the treaty to work out which states have opted out of which rules. Bottom line is, it's actually going to be very difficult to do mobility under the TCA, and invariably you will need to get legal advice before you do it, which is why anyone who's an EU national who was already here should have applied for settled status. And as I've said to you already, remember, settled status was the rights given to EU nationals who were in the UK prior to the 31st of December 2020. And you could apply for it. There's very simple rules on the web. You can apply for it via the app. It's absolutely true, a very short process. There was originally an application fee, but Theresa May did decide to get rid of that. And if you've done more than 5 years, you got settled status on the right. If you did less than 5 years, you got pre-settled status. The key issue here with those who've got pre-settled status, who've got less than 5 years, is that they must remember, once they have done 5 years, to apply for settled status. It doesn't happen automatically. And actually, there's a legal challenge at the moment to say that that's not compatible with the withdrawal agreement. You should, if you've only got pre-settled status, you should eventually get settled status without having to make a formal application. And there will be millions of people caught out by that. It's about 52% have been given settled status, so 48%, you can't make this up, have been given pre-settled status. And there'll be millions among those, at least tens of thousands amongst those who will not remember they've got to apply for settled status. There's still huge amounts of confusion. Now, there is real concern of a risk that we may experience Windrush 2. Why? Because all of this process had to be done by the 30th of June last year. And if you hadn't applied by then, you were in something of a legal limbo. Now, again, to be fair to the government, this legal limbo has been mitigated somewhat by the government being quite flexible about you showing reasonable grounds why you were late and why you didn't hit that deadline. And in fact, what we know now is that there are thousands and thousands of children who've got no status at all, because lots of parents didn't realize that they needed to apply for settled status or pre-settled status for their kids. They thought it only applied to them. So there are thousands of kids who haven't got either of these statuses, but as children, they can apply up until they're 18. So there is something of a safety net. And other reasonable grounds would be things like you've got dementia or you were too sick to apply. And at the moment, the government is being fairly generous about that, because they are very mindful that they don't want to be exposed to a Windrush 2. If you remember, however, I said to you there were about 6 million applications. Now, no government scheme has ever achieved 100% registration. And even if you're only talking about 1% of non-registration, you're already talking something like 60,000 people, a couple of percent, 120,000. And before you know it, there will be people who are not registered. They do not have any status at all. The figures, as I say, are high. Can you see it was at the end of October 2021, which is the latest set of figures, it was nearly 6.3 million people had applied. Note already about 250,000 applied after the deadline. There's a big backlog at the moment because there are lots of people applied right up against the deadline and their cases have not been processed. So to summarize where we've got up to, it's a good thing for you if you've got settled or pre-settled status, if you're coming into the UK or you're a UK national going into the EU. That is a good place to be, because if not, and you're a European citizen, you have to do battle with the sheer complexity of the rules under the TCA, of which I've just given you a brief introduction. And if you do not fall under the TCA and you're trying to come into the UK, you would then, if you don't have settled status, you don't fall under the Trade and Cooperation Agreement, then you have to go through the visa process. Now, the visa process, it must be said, has at one level got more relaxed. You can get a skilled worker visa if you have the equivalent of A-level in terms of your qualifications. So you might just question how skilled the skilled level is, but anyway, the government wants to talk about skills and they say that's good enough. So at first sight, you say, gosh, all I need to do is to have A-levels and I can get into the country. Hold on a sec. It is nowhere near that straightforward, because you've also got to tick all sorts of other boxes. You've got to have a job offer from an approved employer sponsor who has a certificate of sponsorship. And then you've also got to be doing a job that's on the list of eligible occupations. And if you look at the list of eligible occupations, it's a very odd list, because as you can see from the examples I put on the slide, if you're a ballet dancer or a fitness instructor or a florist, that's on the list, so you can come in. But if you are an HGV driver, weren't we short of them? You're not on the list, and therefore you cannot get a skilled worker visa. And so this is a really serious problem. This list has not kept pace with what's needed. And the problem is, of course, it's government mandated. And the moment it's government mandated, you discover that government can't keep up with the market. So you've got to work for an approved sponsor. The sponsor's got to have certificate of sponsorship. You've got to be on the list of, your job's got to be on the list of eligible occupations. You've got to have the equivalent of A-level qualifications. That's not so hard. You've got to speak pretty good English. And then the other thing is you've got to be earning 25,500 for the job, or more if the going rate for the job is higher, and there are lists of this. Now, if you're on the shortage occupation list, you can actually earn less, bizarrely, than those thresholds. And you might have noticed that not just senior care workers have been put on the shortage occupation list, but so have anyone working in social care, because there's such a chronic shortage of that. Note again, HGV drivers aren't on the shortage occupation list, even though we know that there's a shortage. Good news for universities, we can carry on exploiting PhD students. They don't need to be paid the 25,500, they can be paid less. Now, all of this is incredibly bureaucratic, and although it's absolutely true that it's much less demanding than it was, if you're a small business and you've never hired anyone on a visa before, you will be shocked at the amount of paperwork you've got to complete. You will also be shocked, as will anyone you want to employ from the EU, at the cost of visas. We have the most expensive visa scheme in the world. If you're coming for 5 years to go and work in a university, for example, you're coming for 5 years, and you're bringing your spouse and your 2 kids, it will cost you £20,000 just in terms of visa fees and the healthcare service surcharge and various other training charges that are put on the top. And lots of employers, including my own, are refusing to cover that for individuals. So for all the talk about us being a global system and how we're keen to attract the brightest and the best, yes, we have quite generous rules, nothing compared to free movement, but we have quite generous rules. But the cost is so eye-watering, it will become impossible for lots of small businesses and universities and other third sector organizations to actually pay for anyone to come. Now, the key thing about the skilled worker route is that you can settle at the end of 5 years. You can, it does provide a pathway for settlement. The government, of course, don't want more people settling here. So what they've done is introduced temporary work. We've long had seasonal worker visas. We've done temporary work visas, and these have been used extensively to try and patch up the problems that we have got in the supply chain. So you might recall the UK said you can come as a seasonal worker to do poultry work just before Christmas to try and deal with the problem that we didn't have enough people working in chicken factories. You could come to drive HGV lorries. You could come as a pork butcher. But crucially, because they're temporary work visas, therefore they're only there for a short time, and it doesn't provide you with a pathway to stay. There's still a cost, much less than for the visas I was talking about before, but you can't bring your family members. And crucially, nor can you as an employer go and get somebody yourself from Romania who might be able to work for you. You have to use one of 4 agencies, agencies like Fruitful Jobs, and the clues in the title. They are experienced in collecting fruit pickers. They are not experienced in finding pork butchers. And this is one of the reasons why there are still mass culling of pigs on farms. So I'm going to come back to that in a moment. And then, so the temporary visas have been used to try and attract those groups of people who, where there has been a shortage. Then there was a temporary concession at the time of the fuel crisis, when for 15 days, HGV drivers from abroad could come and allowed to work. They weren't even given visas, they were allowed to work. Now, what's remarkable is the lack of transparency about all of this. We have no idea how many people have actually come. I put in an FOI request to the Home Office in November asking how many people had come under the various routes. What we know is that the government said that they would offer 30,000 for work in horticulture. They would offer 5,500 for those working in the poultry industry, 5,000 to drive HGV lorries, and there was no cap for that last minute fuel driver. I put in an FOI request to say how many have actually come, and I was refused the information on the public interest ground that it wasn't in the public interest to know. I appealed the decision, and I said in between times, actually the minister appeared before a select committee and gave some numbers. In the light of that, maybe there is a public interest to know, and could you tell me? And I lost the appeal as well. They said, no, it's not in the public interest. So we don't actually know. What we can say is it looks like on that fuel scheme, 27 people came. That's what the figure the Times produced. Poultry, we think it was somewhere in about maybe 2,000 to 3,000 came. For HGV drivers, it's thought to be 20 out of 300 or so. We just don't know. But if you think about it, would you really want to rush to the UK to work in those sectors? It takes some time to process the visas. It takes at least 3 weeks. Maybe the money is attractive. Maybe the money is good. Certainly if you're from Ukraine or Moldova, the money still looks good. But of course, the scheme was set up just before Christmas, and Christmas is a time when even Ukrainians and Moldovans might want to be with their families. And so, in fact, what we've seen is very few people we think have come, but we just don't know for sure. Which brings me to I want to just say something about pigs. Now, turn away now for those of you who are of a sensitive disposition. So pig industry been hugely successful, and in fact this year or the last year has been more productive than ever. Pigs in the UK are grown to a size of about 120 kilos, and then they get slaughtered at 120 kilos. And our abattoirs are set up to take 120 kilo pigs. Now, what was happening was that following lockdown, quite a lot of abattoirs found that their staff had decided that they wanted to go back to their own countries. So the abattoirs are primarily staffed by Eastern Europeans. And they were down about 25% of their staff. Now, as I've just shown you, it's not easy for an abattoir to get someone under a skilled worker visa, because while butchers are on the list, the salary may be less than 25,600. And indeed, what you see is that these abattoirs are just not set up to have proper sponsorship status. And the fact is, lots of other countries in the EU are also looking for butchers. Long and the short of it was the pigs on farms were getting bigger and bigger. Abattoirs were saying, we can't take these pigs because we don't have the staff to kill them. And what do you do? Now, there is a real problem, because by this stage, a lot of these pigs had got up to somewhere in the region of 160 kilos. And when they're at that size, apparently pigs become really quite a handful. They become a handful because, unlike other European countries, we do not castrate male pigs because we think that's an unnecessary intervention in the pig's life. And so, but when they get to the size of 160 kilos and you're dealing with an uncastrated male pig, they can become quite violent to humans and also to other pigs. And indeed, they engage in cannibalism, I'm told. And so this is why it become crisis point for these farmers. And remember too that they're like rampant teenagers and they eat absolutely everything in sight. And the margins on these pigs were already very small. Long and the short of it is that these pigs are being culled in farms. It's thought there's about 100,000 pigs, healthy pigs need to be culled. And one of the things that I've learned from doing a bit of work on this with my colleagues from the vet school, as you can imagine, I'm not at all qualified to make these observations about pigs until my colleagues, my vet colleagues explain this to me, is not only is it ghastly for a waste to be killing perfectly healthy pigs, which then get rendered, they don't go into the food chain, but also they really emphasize to me the very serious mental health consequences for farmers having to kill animals that they have raised in very animal welfare friendly conditions. And this problem is still ongoing. For those of you who are early birds, it's worth listening to Farming Today, which has been doing some very good coverage on all of this issue. The story's gone off the front page of the newspapers, but it is still a very real problem. And it's a real problem caused by Brexit, by people, Eastern Europeans going home, by the fact that the visa scheme is not flexible enough. And the government has essentially admitted it's not flexible enough, which is why we've had these temporary arrangements. And also, to be fair, there is an issue that China was buying a lot of British pig meat, which they have cut back on because their own pig industry, which had been affected by disease, is coming good again. So there is a lot of pork. There's a lot of pork too in Europe. Now, you might say, well, look, this is the operation of the market, and the market is dealing with these problems in the only way it can. But the real risk, it seems to me, is that we do have high standards of animal welfare. And if these pig farmers go under, yes, we'll be able to import pig meat from abroad, but of course the animal welfare standards there are worse. And so we're essentially contracting out the problems that we have created. So this cartoon almost made me smile on the issue of dealing with both the pig crisis, but also the bigger question of what on earth is happening to our politics. And on that note, I will stop.